Good morning, friends. My today's topic is about Section 138 of Negotiable Instrument Act 1881. That is, dishonor check for insufficiency of funds in the account. Where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part of any debt or other liability is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is sufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank. Such a person shall be deemed to have committed an offence and shall, without prejudice to any other provision of this Act, be punished with imprisonment for a term which may extend to 2 years or with fine which may extend to twice the amount of check or with both, provided the check has been presented to the bank within a period of 3 months from the date on which it is drawn or within the period of its validity, whichever is earlier. Second condition is the payee or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of check as unpaid, and drawer of such check fails to make the payment of the said amount of money to the payee, or as the case may be, to the holder in due course of the check within 15 days of the receipt of said notice. So when these three things are over, then the offense has been committed. It is different thing whether he avails the facility of uh, registering or prosecuting that person under one section 138 of the NIA Act or not. It is upon him. The offense is complete. It, it is further, he has to file the complaint within 30 days after giving him a notice of 15 days that are over. Then he has to 30 days after that he can file the case. It depends upon him to proceed in this way or to go through civil suit. It is his choice. Now there are so many questions relating to this which I have been asked by so many persons. I am replying to them one by one. First question which came to me is whether this can be compounded or it is compoundable offense. Yes, it can be compromised between the party. One section 147 makes offense punishable under the provision of NIA, compoundable. If the original complaint comes to the complainant comes to the court and says that he is withdrawing himself from prosecution on account of compromise and he has compounded the matter, then the conviction and sentence have to set aside. No formal permission to compound the offense is required. This has been decided in Ramesh Bhai, Sam Bhai Patel versus Dinesh Bhai, Achalanand Rathi. This is case of 2004 SCC Gujarat 469. No doubt the compounding requires the consent of both parties. Even in the absence of sub-consent, the court, in the interest of justice, on being satisfied that the complainant has been duly compensated, can in its discretion close the proceeding and discharge the accused. This was said in, this is the ratio of meters and instruments private limited versus Kanchan Mehta of 2018, SCC 560. The question is whether Section 4A2 CRPC can be used to quash the complaint, that is, before High Court, under its inherent power. The answer is, if the accused wants the process under Section 138, that way Section 141, to quash by filing a petition under Section 482 CRPC, he must make out a case that making him stand the trial would be an abuse of the process of court. Then the court will allow. This is the ratio of Gunmala Sales Private Limited versus Anu Mehta, 2015, Volume 1, SCC 103. Now question is where to file case under Section 138. Two parts are of this answer. First one is if a check delivered for collection through an account. If the check is delivered for collection through an account, the case will be tried by the court not inferior to that of the Metropolitan Magistrate or Judicial Magistrate of first class, within whose local jurisdiction the branch of the bank where the payee or holder of in due course, as the case may be, maintain the account is situated. This is as per section 142 subclause 2A. Next question is, if the check presented for payment by payee or holder in due course, otherwise through an account, in such a situation, the case will be tried by the court not inferior to that of the Metropolitan Magistrate or a Judicial Magistrate of the first class, within whose jurisdiction the branch of the dry bank where the drawer of the check maintains the account is situated. This is as per section 142 subclause 2B. Now comes if there is grantor in the deal, he has given the check, whether he is liable. The answer is the word any check and other liability in section 138 clarifies the legislative intent. If the check is given towards any liability which may have been incurred even by someone else, such as in the case of grantor, the person who draws the check is liable for prosecution in case of return of check. This is the case ICDS Limited versus Bina Shavir of 2002, 6 SCC 426. Now the next question is whether mens rea are required for offence under section 138? No. Answer is no. Mens rea is not required. Why? The answer lies in the objective of the parliament. The objective of the parliament was to strengthen the use of checks, distinct from other negotiable instruments as mercantile tender, and therefore it becomes essential for section 138 to be freed from the requirement of proving mens rea. Mens rea means guilty state of mind. This has been achieved by deeming the commission of an offence due mens rea not only under section 138 but also by virtue of the succeeding two sections. What are the succeeding two sections? Section 139 and section 140. Section 139 carves out the presumption that the holder of the check has received it for the discharge of any liability. And section 140 clarifies that it will not be available as a defense to the drawer that he has no reason to believe when he issued the check that it would be dishonored. It is the ratio of Dashrath Roop Singh Rathod versus State of Maharashtra 2014, Volume 9, SCC 129. Can the case be filed if the check is presented for encashment more than once? Answer is yes. The holder or payee of check may present the check for encashment on any number of occasions within the period of his validity, that is 3 months from the date of issue. A dishonor, whether based on a second or any successive presentation of check for encashment, would be a dishonor within the meaning of section 130. This is the ratio of MSR Leather versus S. Palan Pan of 2013, Volume 1, SCC X177. So there are so many other related cases. You can please call me, WhatsApp me. I will answer them in next my video. This is all about this section. Thank you for watching. God bless you all.